Hi, everybody. This is Charles C. Let's go on ahead and get started. I appreciate you all joining me today. I'm going to go on and apologize for my scratchy throat. I've had the Kentucky crud that will not let go. Fortunately, I think I sound better than I did earlier today. But anyway, thank you all for joining me. We've got a lot that we're going to cover today. Want to start off by giving a shout out to everyone out in California that I saw last week, attended and spoke at some Wealth Bowls, and it was just a wonderful time out there. I was in the Palm Springs area. Beautiful place to be in January if you're from the East Coast. So very happy to be with everyone out there last week. So let's go ahead and get started. Want to start off by just reminding everyone why NetLaw is in existence. You know, we really strive to be a tool for you all. We strive to be a tool for your clients. We want to put those tools in the hands of everyone so that they can take care of the essential documents that are important for everyone really to protect themselves and their families, and we've done so in a way to make this a very easy, convenient, and affordable way to protect themselves. You know, NetLaw was founded by the law firm of Hargrove Madden, which is an estate planning law firm based here in Kentucky. Excuse me. And we designed this technology to be a tool in our practice, and that technology was recognized by the American Bar Association in 2012, and we were awarded their James Keene Award for Excellence in E-Lawyering. So I want to make sure you guys understand what that means, because that is truly one of the biggest differentiators for NetLaw when it comes to this particular space. We get a lot of questions about how is NetLaw different, what should I tell my clients when I'm discussing this particular product and they ask me why should I use this instead of LegalZoom or some other online document company. You know, NetLaw is the only company out there whose technology was recognized by the American Bar Association. And that's a big deal, you know, because that's the organization that regulates attorneys and law firms. And so for us to be able to say that our technology was recognized by the American Bar Association is really quite an achievement, and something that you guys need to be promoting when you're talking to your clients, and just the quality of the product and the documents that they're able to create on their own through the NetLaw product. I want to remind you guys that we have extended the excuse me again, I'm so sorry, the buy one, get one free offer through January 31st. I was surprised when I was in California that I met many agents that were not aware that we did that in December, and was terribly sorry and disappointed to hear that they didn't know about that and were not able to take advantage of it. But the good news is we have extended that through January 31st, and I really encourage you to take advantage of this offer. It's been a phenomenal success for the agents that actually knew about it, and it's just a great way to promote this and have the ability to help more families. So the way this works is with the buy one, get one free, when anybody buys a plan, whether it's a client or yourself as an agent, this is open to anyone. When anybody buys a NetLaw plan through WFG, they receive a free plan that they can then gift to someone that they love or care about. The free plan is exactly the same as the paid plan. So the paid plan, we'll go over the documents included in the plan in just a moment, but as you know, the paid plan also includes documents for a spouse. The free plan does as well. It has all the same functionalities and abilities, bells and whistles, what have you, as the paid plan, so there's no difference. So again, anyone that buys a plan before January 31st will receive a free plan that they can then gift to someone. What they would need to do at that time is the person that purchased the plan would need to call into our support center and then give us the information of the recipient, and we will then make sure that that free plan is delivered to the recipient so that they have the opportunity to create documents for themselves. So please take advantage of this. Again, this is the only time we've ever done this. I did not expect that we would extend it through January, but we got such a huge response. And with the holidays and New Year's resolutions and everything, we were convinced by many of you in the field, I won't call names, but many of you were very persistent in reaching out to me and asking that we extend this, that we decided to go ahead and extend it through January. So take advantage of this while it lasts. Now, another really exciting promotion I want to talk to you guys about, and not to confuse you, but as you know, we typically do quarterly contests. We're not going to do that this quarter. Instead, what we're going to do is actually start trying to shake things up a little bit. And so what we're doing right now is what we're calling a pop-up challenge. And this is going to run through this Sunday night. So Sunday at midnight, this is when this offer ends. So the way this works is any agent, any and every agent that can refer 2 NetLaw plans before midnight on the 16th, they will receive a $100 Amazon gift card. So that's all it takes is just refer 2 plans. It has to be 2 fully paid plans. It can't be 2 plans on the installment plan, but refer 2 fully paid plans by midnight on January 16th, and you will automatically win a $100 Amazon gift card. So that's pretty exciting. We just want to challenge you guys to see how many of you can refer 2 plans. When I go out in the field and I'm training agents, I usually ask them, because when I'm doing, in the past, I've always been promoting my quarterly promotions, which were always, in the past, refer 5 plans within the quarter or by the end of the quarter and receive some type of gift. And I always ask the agents, how many of you think you can refer 5 plans within the quarter? And everybody raises their hand. But inevitably, we only have about 5 people by the end of the quarter that have actually hit that mark. So I challenge you, I challenge every single one of you to see if you can refer 2 plans by midnight Sunday night. I want to see how many of you can do it. If you think you can do it, send me an email, because I want to see if you actually do. I think that would be really interesting to see. I challenge you, number one, not only to do it, but to let me know that you're going to do it, and then prove to me that you did. So if that works for us, then we'll probably continue to do similar types of weekly promotions, and maybe even at greater value for the agents in terms of their rewards. So let me know that you like this, and if you do, show me that it can be a success, and we'll continue to do this with, bigger and better prizes. So I hope that sounds great to you guys. I'm really excited about it and can't wait to see what you guys do with it. Let's talk a little bit about the documents that are included, excuse me again, so sorry, included in the plan. And this is, again, pardon me while I take a sip of water. Included in the plan are the documents that you see here: your last will and testament, probate avoidance revocable living trust, power of attorney, that's your financial power of attorney, and it is a durable financial power of attorney, medical power of attorney, living will, also known as an advance directive, HIPAA authorization, life vault. It also includes access to our national network of estate planning attorneys. Remember, the access is a resource. The actual attorney time and services are not included in the cost of the plan, but what is included at no additional cost are documents for the spouse. So 2 sets of documents, one for each of the spouse, each spouse, husband, wife, or spouse and spouse, at the cost of $500. So the fee covers your clients fully for the first year, gives them unlimited changes to those documents at any time and as often as they need to make updates. Also includes unlimited document storage in the life vault. After the first 12 months, if the client wants to maintain full access to the account, it's an $8 a month fee, so less than $100 a year, and your clients have the ability to make sure these documents always reflect their current wishes. This is a completely optional fee. They are not required to maintain the account. If they decide not to continue paying the maintenance fee, that's perfectly fine. They maintain everything that is in their vault at the time that their account goes inactive. They just lose the ability to make changes to those documents, and they lose the ability to continue to add new documents and information to the vault. We do have a reinstatement policy. If it's been less than 60 days that the account has been inactive, there's no cost to reinstate and reactivate the account. If it's been 3 to 6 months, it's a $79 reinstatement fee, and that activates the account for 60 days, during which time the client has full access. They can make changes to their documents, upload new information to the vault, and if they want to keep the account active, they just start paying the $8 fee from that point forward. If it's been longer than 6 months, it's a $250 reinstatement fee. Again, that activates the account for 60 days and gives the client the full access during that time. If they want to maintain full access, they just begin paying the maintenance fee from that point forward. So I think that's pretty straightforward and clear cut, but let me know if you have any questions on the fees or the reinstatement cost. So let's talk about funding your revocable trust. I'm going to take another break here and have a little sip of water, so hopefully I can get through this next piece without coughing at you guys. Okay, so funding your revocable trust. This is one of the areas where we get most of our questions. We get a lot of questions about this, and I can understand it can be very confusing, and sometimes people can be intimidated by just the thought of doing this. But it's truly not that difficult if you know what to do. So what we have done, and for those of you that have been through the plan or have helped the client go through the plan, you know that once the trust is created, that we generate a set of funding instructions that goes along with the document itself, that goes along with the trust document. And it details kind of asset type by asset type how to fund your trust. So a lot of times I'll get questions about, well, how do I find those funding instructions? And then I'll ask, well, have you completed your trust yet? And they'll say no. And I'm like, well, that's why you're not seeing them. It's because you have to create the trust first. When those documents are created and they populate in your vault, that's when the funding instructions, along with all of the other instructions like signing instructions, show up in the vault along with the documents. So, why is it important to fund your trust? What does that really accomplish, and is that a necessary step? Let's talk a little bit about, why you should fund the trust and what it really accomplishes and why it's a good thing for you. And I like to always talk about disability planning first because, a lot of times people think about wills and trusts as being tools for when you pass away. And that's true. They are tools for when you pass away. But your trust is also a tool that can benefit you while you're living. If you've ever been to any of my client presentations or maybe attended any of my client workshops, you've heard me talk about that before. You've heard me talk about, what happens if you don't die, what happens if you've just had a medical event, you've had a stroke or you're incapacitated, then what? Well, with the Revocable Living Trust, along with the financial power of attorney that is included in the NetLaw plan, these two documents are already there, already included in the plan, included in the cost of the plan. These two documents are a key tool for you while you're living, and it's a key tool for disability planning purposes. So, for example, I've got a Revocable Living Trust, and I have a financial power of attorney, and my husband Blake is named as my attorney in fact within the financial power of attorney, and he is named as my successor trustee in my Revocable Living Trust. So let's say that something happens to me. Maybe I'm in a car accident and I'm incapacitated and I can't manage my affairs, and I have not funded my trust. Let's say that's the scenario. Well, since Blake is already named in these very important documents, he can use that power of attorney to move my assets into my trust for me, and then as successor trustee, manage that trust on my behalf according to the terms that I've set up myself for me. So he can manage those assets, pay bills, direct investments, et cetera, et cetera. And that alleviates the need for him to then have to be appointed as guardian by a court. If I had not named him in those documents, if I had not created those documents, that's what he would have to do. He or one of my family members would have to petition the court to be named as guardian for me to handle my financial affairs. But with those documents in place, he avoids that whole process and is immediately able to not only, handle those things for me, but also to care for me by using the funds of that trust to pay for my care, pay for my needs. And that's a great tool, and that's a tool that a lot of times people don't think about when they're thinking about planning. They're always thinking about the future, about after they pass away. And that's definitely something you want to think about, but you also want to make sure that you're protecting yourself during your lifetime as well. And that's a key tool to taking that step. Another reason to fund your trust is the issue of probate and avoiding that whole probate process. And we've all probably heard about probate. Maybe some of you have been executors or personal representatives over an estate if you've had a loved one pass away. And you know that it can be a very time-consuming and a very costly and burdensome process. Every state has what's known as a creditor's claim period, and typically it's about 6 months. There are some exceptions. I think New York is 7 months. I think California is 4 months. And I think there's some states that are maybe even 3 months. But on average, it's about 6 months across the country. And during that period of time, the assets that are in your individual name are frozen by the court. And they do that so that if any creditors come forward during that creditor's claim period, there are assets there to pay those claims. So, it can really burden the family, because if those are assets that the family has relied upon to buy groceries and keep the lights on and, put gas in the car and pay expenses, then it really puts a strain on the family if they don't have access to those funds to continue to support their lifestyle. With the revocable living trust and having your individually owned assets owned by that trust prior to death, you avoid the whole probate process, which means you avoid that creditor's claim period, and you also avoid the fees and costs associated with probate. And depending on where you live, that can be pretty significant, especially for states like California, Florida, and New York, for example. Florida it really comes to mind because it's close to us, and we've had a lot of clients in Florida. And I know from experience that there are statutory fees associated with probate in Florida. You've got your attorney's costs, you've got your court costs, and you couple that with the creditor's claim period, and it can really, really just be just a bad situation for the family, on top of the emotional trauma that they're already going through after the passing of a loved one. So that's a really, really important reason to fund your trust, to avoid that whole process. And then finally, having the ability to protect those assets for future generations. That is very, very essential, I think, for a lot of people, myself included. I know that I want what I've spent my lifetime building and accumulating to stay in my family. I want it to benefit my bloodline. I want it to, benefit my husband upon my passing, and then to benefit my daughter, and then to benefit my grandchildren, and so on and so forth. I don't ever want to take a chance that if I were to pass first, that any future wife of my husband would ever have a chance to get their hands on the money that I leave to him and my daughter. I don't want that to happen. I want to make sure that I'm protecting that. Likewise, I want to make sure that no future ex-son-in-law of mine ever gets his hands on my daughter's inheritance. I want to protect that. And trust planning is a great way to do that. You can not only make sure it stays in the family, benefiting your bloodline, but you can also structure the inheritance in those trusts for those beneficiaries so that they don't misuse or frivolously spend their inheritance. It can be structured so that they get certain distributions at certain ages, meanwhile having the ability to get distributions for their health, support, education, and maintenance. So all of those things are very important and are wonderful reasons why you should, number one, have a trust, and number two, take the steps to fund that trust. So let's talk about how you retitle and fund your trust. And I'll show you here in a moment what our funding instructions look like that come along with the trust, but I want to talk about each of these different categories as well. So titling your assets, and a lot of times we get questions from agents and maybe even from clients saying, I don't see where in the trust I list all of my assets that I want to move into my trust. And there's not a place for that. We don't do that, and it's not required within the trust document itself, and oftentimes it's not really something that you necessarily want to do. Because this is a revocable trust, meaning that the person that sets it up, and I'm using myself here as the example, I have complete control of that trust. It is my trust. I can amend it at any time. I can terminate it at any time. I can put assets into it. I can take assets out of it. I can change the beneficiaries. It's completely at my control. So by listing them either within the documents or as an attachment or whatever, that does not retitle those assets. That does not fund the trust. That does not do anything. You actually have to take steps to retitle those assets. And if I am doing that, if I want to retitle real estate, for example, then I need to have a new deed created. And that new deed is going to have the name of my trust as the new owner. And this is the language that you would use. In my particular case, it would be Charles C. Ballmeyer as trustee, or my successors of the Charles C. Ballmeyer Revocable Living Trust dated blank, which means that I need to have this trust created and signed and fully effective before I transfer the assets to the trust, because you have to actually list the date that the trust was signed within the title documents themselves. Now, with real estate, that's probably one of the more difficult assets to transfer because you do actually have to create a new deed. We are working on a solution for clients. We had at one point a law firm that was helping us on a national basis, but we got some feedback from you guys that they weren't doing a great job. So we pulled them out of that position, and we are working for a better solution for you guys. But to do that, to do the deed, you have to have a new deed. It can be a quitclaim deed or no warranty deed. It's really not a very difficult document. But this is the language that you would need to retitle that piece of real estate into the name of your trust. The reason that document, the deed itself, is not included in our package is because deeds are so particular, not only state by state, but also sometimes county by county, and it can be just a complete nightmare to try to keep up with all the different requirements, not only from each state, but from county to county as well. So just know that we're trying to figure that piece out for you guys. In the meantime, our network of attorneys can help your clients with that process, with creating the deed and also recording the deed to get it of record. Now, let's talk a little bit about tangible personal property. And I get questions about that as well a lot. And when I talk about tangible personal property, I'm talking about clothing, jewelry, furniture, anything that you can pick up and move, basically. And that's really like your household items, pots and pans, anything in your house like that. And generally, that's not an issue from an estate planning or a probate standpoint. Typically, things that are going to be an issue from a probate standpoint are going to be things that actually have a title. Nobody has a title to their couch or their pots and pans, for example. And also, too, those types of assets, when you look at it from a probate standpoint, the value for those assets are very low. And when you go through probate, typically what we would do in the private practice is we would lump all the household items into one category and call that, miscellaneous tangible personal property valued at X. And that value is typically the value that you would get if you were having a yard sale, like a garage sale. It's not a replacement value. So think about what you could sell your asset, your tangible personal property for at a yard sale or a garage sale. And that's typically what, that would be valued at if you were to go through probate and list those assets in probate. Again, you wouldn't have to list every single tiny picture frame and pillow and sofa and bed sheets and things like that. Most of the time you just do one lump miscellaneous tangible personal property with an estimated value. And the reason I say that is because I don't want you to get too hung up on, quote, transferring your tangible personal property into the name of the trust. That can be done, and it certainly is something that you can do. And in our funding instructions, we say that you can do that, and that you may want to do a, quote, bill of sale or an assignment of tangible personal property to the revocable trust. And you would simply use this title language that I've got here listed. And you may also want to just put a general listing of miscellaneous tangible personal property, including any after acquired tangible personal property from the date hereof. And that just kind of does a blanket coverage for all of your miscellaneous property and then anything you acquire after the date of that transfer. So it's really not, that particular piece of it isn't that difficult, and I wouldn't get too hung up on that particular piece. Now, with other accounts like bank accounts, investment accounts, savings accounts, things of that nature, those are really easy to transfer. You're just going to go down to the bank, you're going to go take your trust with you, and it's just a matter of retitling assets. You don't necessarily have to open up a new account and move your checking account, the assets from your existing checking account into a new checking account into the name of your trust. It's really just a title transfer, changing the title of your existing account into the name of your trust. Keep in mind, again, as I mentioned, this is your trust. You're in complete control. So that means that this maintains your Social Security number. You're not going to have a separate tax filing with this change. So you're not going to have to file another tax return in the name of your revocable trust. It's just going to all be listed on your personal tax return just like you always have, again, because it maintains your Social Security number. Now let's talk a little bit about life insurance beneficiary designations. And there's some situations there where you would maybe do a couple of different things. If you are an individual that has minor children, and I'll use myself as an example. So I am married. Many of you know my husband, Blake, and we have a daughter, Brooke, and she's 10. So the way I would do this, if it were me, and again, I'm not giving legal advice. As you know, NetLaw is a technology company, not a law firm. So I'm using this as an example. This is not advice. I have to give that disclaimer. But in my situation, what I would probably do on my life insurance is have my husband, Blake, excuse me, named as the primary beneficiary. And then if he did not survive me, then I would list my revocable trust as the contingent, as the secondary beneficiary, so that the proceeds from my insurance would be paid first to Blake if living, if not then to this trust, so that the successor trustee could then manage those assets for the benefit of my daughter. And that's really important to me because she's 10. I would not want to name her individually as the contingent beneficiary, because that would mean that she would get a big chunk of money outright at age 18, and that's not what I want at all. I want to have those assets held and managed for her benefit until she gets older and more responsible. So that's what I would do. And I think that's very important for anybody that has minor children. Now, that's not to say that you couldn't name the trust as your primary beneficiary if you wanted to. You could certainly do that as well, especially if you've got your spouse listed as the primary beneficiary of your revocable trust. It would just follow the terms of the trust and benefit your spouse first, and then your remainder beneficiaries. So I hope that makes sense. Now, a lot of times we get questions about changing the ownership of life insurance to the revocable trust, and that's really not necessary because, again, it's your Social Security number. It's really not effectively taking that out of your taxable estate. Most of the time when you're thinking about changing ownership of a life insurance policy, it's for tax reasons, and to do that, you would be transferring it to an irrevocable trust, not your revocable trust. And I focused on that in a previous webinar, the differences between a revocable trust and an irrevocable trust. So I won't go into that today. Maybe we'll repeat that later in the year so you guys can have a refresher on that. Let's talk a little bit about retirement accounts. And at this time, what I'm going to do is hop off of this PowerPoint and pull up the funding instructions, because I want to make sure, and this is what the funding instructions look like. I want to make this a little bit bigger so you guys can see it, and go up here to the top. So this is actually what's generated out of our system and what is populated in the vault after you've created your documents. So we've gone over a lot of these. Here's personal property, that tangible personal property I talked about, real estate, bank accounts and investment accounts, stocks and bonds, closely held businesses, life insurance, and now retirement plans. I want to make sure that you guys understand that retirement plans are not subject to probate anyway, much like life insurance. That's why it's not a big deal to not necessarily transfer your life insurance because it passes by beneficiary designation. The only reason you would want to do so is if you have minor beneficiaries and you want to protect those assets until they get older. Now with retirement plans, those also pass by beneficiary designation, so it's not a probate asset. And we really stress that a client talk to their tax professional, to their CPA, to their financial advisors before even considering transferring beneficiary of any type of retirement account to a trust. period, regardless of what kind of trust that is. They need to talk to their financial professionals and their tax advisors, because there can be some severe tax consequences if they do not do so. So again, we have that listed here, but you can see that I've got it, highlighted and bold and underlined that you really, really need to talk to a tax professional before you ever take the steps of transferring or changing beneficiary designations on your retirement account. So again, I'm not a CPA, I'm not an accountant, I'm not a tax advisor, so I'm not even going to pretend like I can tell somebody what they should or should not do with that. I couldn't do that anyway because we're a technology company. So when your clients ask you about the retirement accounts, your answer needs to be, you need to talk to your CPA about that before you do anything with those accounts. So this is what that looks like, and just wanted to show that to you real quickly. Let me go back to my PowerPoint. And with that, guys, I'm going to take a breath here and open some things up for questions. I've had some great help from Scott and Vanessa and Joe helping me with questions today. So let me see if there's any here that have not been answered that I need to address. And again, guys, I apologize for my scratchy throat. It's just been, I cannot kick this this cold that I've had. I had somebody ask me earlier today if I got sick before or after the Alabama game. If you don't know, I'm a huge Alabama fan, and they just lost the national championship. Still crying myself to sleep at night over that. I think that's what made me worse. I think that's what made me have a little relapse in my cold here, was losing the Alabama game. Let's see here. Doris is asking, do we need to print these out and then fill in, or is this a PDF file where we can type in the blanks? Doris, not real sure what you're talking about there. Maybe you're talking about beneficiary designation forms. If that's the case, if it's life insurance, you're going to get that from the carrier. So if it's a Transamerica policy, a nationwide policy, an ING or whatever, you're going to get those designation forms from them that will then be filled out. Let's see here. Let's see. Daniel, can successor trustee be a witness on the documents? It's best that they not be. You really don't want anybody that has any beneficial interest or control over the document to be a witness or the notary, so it needs to be someone independent. That's just kind of best practices. What kind of notary is needed? Anybody that is authorized as a notary in your state is sufficient. Also, too, I want to, for those of you in California, I want to confirm again and reiterate again that the documents, your wills and trust, and all of the documents in the plan can be notarized by any notary authorized in your state, period. If you're getting banks and other people that are telling you that you have to go to an attorney to get those notarized, that is not true. What some of you are hearing that, and what that boils down to, there's a lot of banks and other services, I think somebody said UPS, they just do not feel comfortable notarizing those documents for whatever reason, and that's especially with banks, that's becoming more popular, more common rather. They're not notarizing estate planning documents for liability purposes, or in their mind perceived liability purposes. There are a ton of notary services out there. If you're looking for one, just Google notary services in your area and you will find them. I also encourage you guys to recruit notaries for your team. That's a great way to provide that service. It's a great way to build your team. So again, documents do not have to be notarized by an attorney. Documents can be notarized by any authorized notary in your state, period. Let's see here. Fidel, hey Fidel, how you doing? I got a question here from Fidel saying, can we title assets inside trust similar to the not-for-profit statement currently in the will? For example, I would like to give my car to my son and my wife's jewelry to my daughter and all other assets to be split. Yes, you can title. Well, actually, I'm really not sure I understand your question, Fidel. If you've got the dispositive provisions in the trust for the distribution of those assets, I'm not sure what the title question is. Maybe you want to shoot me another message here and qualify that for me. Let's see here. Rama is asking, is it mandatory to place the assets in the trust once you create it? No, it's not, and I appreciate the question, and I'll explain why that's the case. It's not necessary to do so because our wills and trust work together. Our wills are what's called a pour-over will, and that's P-O-U-R. So you may have heard of that term before, pour-over will. So what the will is going to say is all of the assets, all of my remaining assets upon my death, distribute those over into my revocable living trust. So, quote, pour those over into my revocable living trust. So whether you transfer those assets during your lifetime or they get transferred at your death according to your will, they're going to wind up in your trust at the end. So, and that's really important because a lot of times people will ask me, if I have a trust, do I need a will? And my answer to that is yes, because again, let's say that you just set up the trust and you took all of your assets and you moved it into the name of that trust. And then what do? You put that trust in a drawer and life goes on and you forget about it, right? You're not thinking about your trust every day, are you? No, none of us are. So, life goes on, you buy and sell a property, you get another car, you open another bank account, you move, et cetera, and those newly acquired assets don't get transferred to the trust, and then you pass away. So now you've got assets inside the trust that are going to be distributed according to your trust, and then you've got assets in your name that aren't in the trust and you don't have a will. So those assets are going to be subject to the dispositive provisions of your state law, your intestate succession laws. So that's probably not going to be consistent with how you would want those assets to be transferred. So you want to make sure that you've got both a will and a trust, and you want to make sure that that will references your trust. So very important and good question. Let's see here, what else? Let's see, Daniel, for professionals who are here on temporary visas, can they still benefit from the living trust, and what would the main benefit be? If they're here on a temporary visa and they're not acquiring assets in the U.S., they still may want to take advantage of the U.S. Of the NetLaw trust for the healthcare documents, because while they're here, they're going to want to make sure that they're protecting their, their healthcare decisions, their, management of their financial affairs if they become incapacitated. Also, if they're acquiring assets here in the U.S., maybe they're buying a piece of property. If they're going to be here for a few years, maybe they want to buy a piece of property, or they're buying it for investment purposes. And if that's the case, they're going to want to transfer those assets into a trust to protect them and to also keep those assets from being part of probate. Because even if they're not a U.S. resident, if they die here and they have assets here, they're going to be subject to U.S. Probate laws. So question here, can we notarize documents if we are a notary? So yes, if you are yourself a notary, you can notarize those documents for your clients. And depending on where you live in your state, and if you're a notary, you should know this, you can actually charge for those notary services. In some states, there's a flat fee or a minimum fee and a maximum fee. So just check with your Secretary of State if you're not familiar with that requirement in your state. But absolutely, and really that's one of the things that I tell agents. If you don't have a notary on your team, consider becoming a notary yourself. It's not difficult. I've been a notary myself for 25 years. You go through the process once, and then every 4 years you renew your notary and your bond, and it's like $100 every 4 years or so. So it's really not a big deal. Let's see here. So I've got another question. When property is in a trust, if one of the trustees dies, do we have to sell the property to divide it among the survivors? I think what you're asking here, Saneda, is when somebody passes away, do the assets have to be sold and distributed? And I think what you're saying here, when the trustee passes away, you just follow the terms of the trust. So for example, again, I'll use myself. I am the trustee of my own trust during my lifetime. When I pass away, my husband is trustee of the trust. And that successor trustee just maintains the trust and administers it according to the terms of the trust. So in my situation, it would be for the benefit of my husband and then for the benefit of my daughter. if typically the trust is going to, if it terminates, it's going to terminate upon the death of a particular beneficiary, and that'll be set out in the terms of the document. It really doesn't have anything to do with the trustee's death. Let's see here. What else do we got? Lots of questions coming in, guys. Thank you so much for your attention today. So Ann is saying, I have an old will. How can I tell if the will is a pour-over will? What you're going to look for is a provision that basically says distribute my remaining assets to my revocable living trust, and it will name that trust within your will. So if you're not seeing that, then more than likely you do not have a pour-over will. Dylan has a question here. If a client purchased the plan today, what is the time frame to create their will and trust documents before the plan expires, or does it expire? If they purchase a plan today, they have 1 year of full access to their account, where they can go in and create documents, upload documents to their vault, make changes to their documents, etc. If they don't create their documents within the year, at the end of the year, beginning in the 13th month, if they continue to maintain their account by paying the $8 a month, they'll continue to have the ability to create those documents at any time. Once those documents are created, and they have to be printed, you can't just create them. I mean, that's just the first step, is creating the documents. The next step is downloading and printing the documents. Then the final step, or the next step after that, would be to sign the documents, properly sign the documents according to the signing instructions. So the document may or may not need to be notarized. It may or may not need to be witnessed. There are instructions that go with every single document. And then for the trust, funding it. Once all of that is done, actually once it's properly signed and witnessed and notarized, it's binding and effective forevermore until you terminate the document or create a new document that will supersede it. Hope that makes sense. Let's see, Julie Johnson. Hey, Julie Johnson. Follow-up question from Julie about the pour-over will. Will the assets that did not get named in the trust still have to go through probate? Yes, Julie. If you have assets in your individual name that did not get moved into the trust, those individually owned assets will be subject to probate. Even though your will will get it to your trust after your death, unfortunately, to get there, it's going to go through probate first. Let's see. Fidel, why don't you email me so we can talk about your question a little bit more offline? I think that's a bit more detail that we need to go through just one-on-one. Let's see. Shirley, hi there. She's asking, what about transferring your LLC business interest into the trust? Yeah, that's also something that's covered in the funding instructions, your business entity, closely held business entity transfers. I'll just kind of pull that up and scroll here. Basically what you're going to do, and that would be here under closely held business interest, is, if it's an LLC, you're transferring your ownership interest in that LLC by assignment or bill of sale, or if it's actually certificated by certificate to the name of the trust. So if you are a business owner and you have closely held business interest, most of the time you own 100% of that business, of the interest in that business, or maybe you and your spouse own 50% each of the LLC interest. You would just transfer your interest in that business to your revocable trust. Because those business interests, even though that business is an LLC, if you own that interest individually, it is going to be subject to probate if you do not transfer it to a trust. Let's see here, what else? Bob is asking, how will it affect the refinancing of the house if it is transferred into a trust? It will not affect that, Bob, because like I said, this maintains your Social Security number. And when you transfer the deed, you're not transferring the mortgage. So you can have the deed in the name of your trust, and the mortgage can still be held in your individual name. That doesn't affect the mortgage. The mortgage doesn't affect probate. So those are two separate things, and it should not affect that at all. Let's see here. I'm reading a question here from Nina. She says, a sister wants her brother to get 1/5 of the home after she dies. Will the brother be the owner after she dies. Anything that he needs to do in order to get this in his name. Let's see, she's already transferred her. Okay, so I think what you're saying here, Nina, and tell me if I'm wrong, I think what I'm reading here is Nina saying that this client had 5 homes and she wants a brother to get one of the homes. Basically, that would be yes, he can do that under the will or the trust. She can do that under the will or the trust, and he will get that. There's nothing that he needs to do prior to her death. After her death, if it's already in the trust, it's going to be titled that way according to the terms of the trust. If it goes through probate, then the executor of the estate will then go through the steps to retitle the property into the brother's name according to the wishes reflected in the will. So Janet here is asking, if a client lives in New Jersey, do the documents have to be notarized in New Jersey? No, that's not right. You can actually have documents notarized anywhere. So we do that a lot in our private practice. You know, we're in Louisville, Kentucky, but we have clients that are, you know, maybe residents of Florida. Well, we can, you know, have the documents witnessed and notarized in Kentucky or, you know, Indiana documents or what have you. Because what you're doing is you're authenticating the person's signature. You're not authenticating the jurisdiction of the documents. Let's see here, what else? Another question is, the documents actually say they are a living trust. Yes, that's actually reflected in the document, Revocable Living Trust. Let's see here. So Judith here is asking, can a spouse have A and B trust? I think what you're asking, Judith, is can they have a joint trust or can they have separate trust? And the answer to that is, if they live in a community property state, yes, they can have either one joint trust or they can have separate trust. In all other states, in non-community property states, you're going to be creating a separate trust for each spouse. Only community property states have the ability to create a joint trust. Let's see here. Zenaida, yes, we did talk about that. She's asking about transferring bank accounts into the name of the trust. Yes, that is something that if it's in your individual name, anything titled in your individual name is something that you would want to consider transferring to a revocable living trust to avoid probate. Let's see here. Gina's saying here that some lenders won't lend to a revocable trust. They want to take it out. And that's true. Some lenders won't, which is why I mentioned before, you do the mortgage, the loan against the property does not need to be in the name of the trust. The loan or the mortgage against the property can be in your individual name while the deed itself is in the name of the trust. Let's see. So another question here, is there a need to create a joint trust for husband and wife that have already created their own separate trust? What's the benefit of a joint trust? Again, if you're in a community property state and you have community property, you have assets that qualify in your state as community property, then you probably would want to consider creating the joint trust to own that community property. If you do not live in a community property state, then that is not necessarily a concern, and which is the reason why we do not offer joint trust in non-community property states. The administration of a joint trust after the death of the first spouse can be quite burdensome in a state that is not a community property state, which is one of the reasons, again, why we do not offer joint trust in non-community property states. So I've got another question here about notaries. Just to confirm, you can have your documents notarized anywhere. You do not physically have to be in your state and have the documents notarized in your state. For example, we've got a client in California who was living in California, but she was a legal resident of the state of Florida, so her documents were subject to Florida jurisdiction. She had those documents notarized in California. So again, the documents are subject to Florida jurisdiction, but she had them notarized in California. As long as you can prove that you are who you say you are, that you are of sound mind, and you are not under any undue influence or duress, those documents can be notarized outside of your state of residency. Let's see here. So another question here is, how often do you have to update your trust or will once everything is signed and notarized? How long is it valid? It's valid for forever unless you need to make a change. So unless you need to update your documents, unless you have the need to change beneficiaries, add beneficiaries, you know, things of that nature, change the dispositive provisions. Unless you need to make a change, you don't have, there's not a requirement that you update it at any time. Only if there's been a life event, only if you're making a significant change to the document, such as, again, making changes to how the assets are paid out, who they're being paid to, etc. There's no, that they're valid and effective and binding forever. Okay, Cheryl is asking, does a living trust document have the ability to put restrictions on how the funds are distributed to children? Absolutely, yes. Absolutely, yes. That is definitely part of the NetLaw plan. We do have several different dispositive provisions to choose from for different ages that the beneficiary can get outright distributions. It restricts those assets from being paid to creditors, from being paid to, you know, spousal interests, spousal rights of the beneficiary. So yes, those are protected. So Roma's saying here, I heard that it's good to review your plan every year or 2 years. Yes, it is. That does not mean that you have to update the documents every year or 2 years. If there haven't been any changes in your life or any changes that you need to make to the documents, you don't have to. But like with any financial plan, your estate plan should be reviewed, and you should be encouraging your clients to sit down with you at least once a year. I would say at least once a year, to review their financial statement, to review their beneficiary designations, and to review their estate planning documents to make sure there haven't been any changes in their life for which they would need to update those documents in their plans. Let's see here. So Daniel's saying, if we make changes to the trust, do we need to redo the funding of the trust? No, you don't. Only if you're creating a new trust and you want to move assets to that new trust. If you're just making an amendment to the existing trust, you're not transferring assets again. Let's see here. Lots of questions coming in. So Nina here is saying, a client wants to know the difference between getting a trust and will packet through NetLaw versus going to a lawyer or a law firm. Great question. The biggest difference in my mind is obviously the cost. You know, some of you may have heard me say that if you were to come to the Hargrove Madden firm, you know, the firm that created NetLaw for this package of documents, it would be $3,500 in Louisville, Kentucky. You all are able to offer the same set of documents to your clients for $500. And one of the things that I like to emphasize and point out is this technology, again, the technology that is owned by NetLaw, the technology that your clients use to create their documents, is the same technology that we still use in our private practice at Hargrove Madden to create documents for our clients. So if your client were to come to Hargrove Madden for this set of documents, they're getting the same documents created with the same software that they would get if they created it themselves with NetLaw, but they're paying $3,500 versus $5,000. The other difference, obviously, is NetLaw cannot give legal advice. We're not a law firm, we're a technology company. So if your client has a situation that they truly need legal advice, then they would want to go see an attorney or connect with one of our network attorneys for that legal advice. And so what is an example of legal advice? That would be, for example, let's say you've got a client and they've got 3 kids one of the kids is very successful, been married a long time, no issues, etc. One of the kids has a substance abuse problem. One of the kids is on their third marriage and they have a lot of creditor debt. And the client were to ask, well, how do I leave my assets to my two children that have these issues? Do I, cut them out of the will? Do I, what do I do for them? Well, that is, to answer that question would be giving legal advice, and you can't do that. And if they are asking questions like, well, I think I have a federal estate tax situation. How do I avoid that? What can I do to reduce or eliminate that tax? Again, that's a question of legal nature, and that's something that they would want to connect to an attorney to have those questions answered and to get the services to resolve those particular needs. For the vast, vast majority of Americans, they can protect themselves with the documents that they can create on their own with NetLaw. Again, if they have unusual circumstances or unusual situations, maybe they have a child or a beneficiary with special needs, maybe they have a child with Down syndrome or autism, or whatever the case may be, they're going to want to connect with an attorney for advice on how to handle those situations and to create more advanced documents to handle those types of planning situations. I hope that makes sense. Let's see here. So question here from Cheryl, do we have to determine who should receive the free one by a certain date? The client that purchased the plan, so the purchased plan, the client that purchases the plan will need to contact our office within 12 months to give us the recipient's information. And really the sooner the better, because that free plan is good for the duration of the paid plan. So the paid plan is good for 12 months. The free plan runs parallel to those 12 months, so the sooner we can get the free plan into the hands of the recipient, the more time that recipient will have to create their documents. Let's see. Where can we find, okay, where can we find your client talk for clients to view? Let's see here. Let me do this for you. Let me hop off this PowerPoint and go to the agent resource page. For those of you who have not been here, this is wfg.netlawinc.com. I want to point out up here at the top, this top green line up here at the top where it says Client Workshop Invitation. This is a great resource for your clients and prospects. It's also a great resource for you as an agent if you're not that familiar with our system. This is something, and again, this is an invitation. You can copy and paste this URL and blast it out to your clients and prospects. But this is going to give them the schedule for the January client workshops, and they can just choose which one they want to attend. And these are hot links here. So by clicking on one, that's going to pull up the registration page where they register for the webinar. They'll then get the email with the link to click to join the webinar once it's in progress. So that's how they can get more information on the how to use the system. I spend about 20 minutes in the beginning of the workshop going over estate and probate education. And then I go into a client account and actually show them how to get started, how to enter information, how to create documents, how to download documents, how to upload documents, how to use the resources, etc. So that's a great tool for your clients. Also want to point out here, the agent training webinar schedule is here as well for those of you that are new to NetLaw or you just need a refresher. Go right here and click on that link to get the schedule. And again, there are hot links in there, so you would just click on the date that you want to attend and then register for that particular webinar. Also want to point out here is more information on the buy one get one free offer if you're wanting more details on that. This is where you can go to get those details, terms and conditions. It's right there. We've also got the pop-up challenge that I talked about when we began. It's listed here. So if you joined us late, I want to go over that again. We are starting something new this quarter. In the past we've done quarterly contests, and now we're not. We're going to do these little pop-up challenge. And the pop-up challenge that began today and runs through midnight on Sunday. So midnight, which is actually, I guess, 12 o'clock a.m. on the 17th, but midnight on January 16th. If you refer to NetLaw plans between today and midnight Sunday night, we're going to give you a $100 Amazon gift card. Now, it does have to be a fully paid plan. It cannot be a plan on the installment option. And we just want to see, how many of you can do that. We've challenged you to see if this is something that you think you can do, and I can't wait to see how many of you actually hit that mark. A lot of times you guys tell me that, oh, that's easy, I can do that, but then, maybe one or two people do it. I want to see how many of you can actually do it. So, show me what you can do before midnight Sunday night, and I hope that I give away thousands of these Amazon gift cards on Sunday. So also want to point out to you guys that there's no waiting period to get your gift card. As with the past quarterly contest, we've made you all wait for 31 days after the date of your last sale that qualified you for the contest before we awarded the award. With this pop-up challenge, you're going to get your Amazon gift card right away. So no 31-day wait on that. Really excited about that. Yeah.
Real quick, your screen didn't update. We're getting quite a few requests for you to show the client registration page. If you could just scroll the WFG website, wfg.netlawinc.com. Hopefully it's not a tech glitch here.
What are they needing to see? The client registration for the workshop?
Yes.
Okay. Can you see my screen now? I'm on the home page.
No, we see your PowerPoint slide.
Okay. Hang on a second. Can you see it now?
No. Must be some sort of PowerPoint glitch. So if you visit wfg.netlawinc.com, on the green menu bar on the very top of the screen, you'll see Client Workshop. Just click on that. It'll provide you with all the dates.
Absolutely. We're running a little over time, so I don't know if that has anything to do with my ability to share my screen. That might have something to do with that. So with that, guys, since we are running a bit over and it looks like I'm having some problems, some tech problems showing you my screen, let's go on ahead and wrap things up. If you all still have questions that you need answered, please just reach out to us and let us know. You can contact our support center. You can contact me. Whatever works for you guys, and we're happy to help you. If you're having trouble seeing my screen, the contact number for our support center is 1-888-604-4789. Again, that's 1-888-604-4789. Or you can email us at support@netlawinc.com. Again, support@netlawinc.com. Thank you so much, guys. Have a wonderful day, and we look forward to hearing from you. And otherwise, I will be speaking with you on the next webinar. Thanks, everybody.